Was someone breaking into your home, right? A castle doctrine event. In a presumption state, if the answer is yes, a break-in was in progress, then the answer is not guilty.
Yeah, or should be. We are the Armed Attorneys. Today we're talking about proposed legislation that takes aim at criminal alien trespassers. We're going to be talking about what the law is in this state, what this change would, proposed change would do, and is this a good model for other states? Is this something that we should implement elsewhere? But before we begin, show your support for the Second Amendment by hitting that like button. And before we get started, I just want to throw this up real fast. I saw 6 Hour got kicked off of Instagram. The writing's on the wall for gun organizations, 2A advocacy groups, and things of the like. So we are going to be responding to that with some kind of big plans coming down the pipe. Stay tuned. We're going to be talking about that. But today's video is also brought to you by our friends over at American Hartford Gold. We'll talk about them in a little bit. But what are we talking about, Emily Taylor?
Okay.
Also, whose chair are you sitting in?
I know our producer Jen has the tablets have been written. They've come down from on high. We are switching spots. So here's what we've got. We have two sick armed attorneys who are going to do their best for you today. So there is a difference, right, between your self-defense statutes. There's really two layers of self-defense statutes. There is your presumption statutes, which some states have, some states don't. If you live in a state that has them, that's great. Arizona is one of those states. And then there are just your regular justification statutes. So what is a presumption statute? A presumption statute actually takes that self-defense determination away from the jury in a really important way. And what it does is say, if a certain event is occurring, you are presumed reasonable in your use of force or deadly force. And then the jury is asked, not if you're reasonable, not if deadly force was the right thing. They are simply asked, was the event occurring? That is very, very important. So, for example, was someone breaking into your home, right? A castle doctrine event. In a presumption state, if the answer is yes, a break-in was in progress, then the answer is not guilty.
Yeah, or should be.
It should be not guilty, right? You are presumed reasonable. So the jury is not second guessing. They're not Monday morning quarterbacking your use of deadly force. They're simply saying, was the predicate event happening? If yes, not guilty, not looking at the reasonableness of your act, right? Your reasonableness is presumed. Whereas just your general blanket justification statutes, you're saying, okay, it's almost like a two-step question is the way I like to look at it, is number one, was the force or deadly force potentially authorized by statute? So let's say, was someone a trespasser on your property? Yes or no? If the answer is no, they had a right to be there, this inquiry stops, you are probably guilty of whatever you did. But if answer is yes, move on to question two. Question two, was said use of force, let's say, reasonable? Would an ordinary and prudent person have engaged in the same use of force, or would they have just yelled at the guy? Would they have retreated and called police? Would they have simply shoved the person off the property rather than displaying a firearm? Whatever, what have you, right? It is peak Monday morning quarterbacking. And so we have these two different layers of statute. Again, that's if you live in a good state. If you live in a bad state, you've only got that second layer we talked about. And what Arizona has done, by the way, because you're going to see articles, it's like they're modifying their castle doctrine. They're making all these changes. No, they are modifying layer two. No legal presumptions. Simply, when can we make this available to someone where then the jury can second guess them? So what exactly did they do?
Yeah, so disregard headlines that says ranchers now legally can hunt illegal alien trespassers. That's not really what the law is doing here. And the law we're looking at is HB 2843. This has already passed out of the Arizona House, making its way over to the Senate. And it is a slight modification in the law. And I will just say there's kind of a practical aspect to all of this because, and we see this happen a lot, where there isn't really a substantial change in the law, but if people are misinterpreting it or if there's some confusion, sometimes you make these little changes to make it crystal clear, hey, you have the certain right to do X, Y, Z. Well, if everyone's under the false impression that, hey, I don't have a legal right to do this, and then they change a word, and that's kind of what we're doing here. That's the legal clarification they're seeking, and essentially what they're doing is clarifying the definition of premises.
Right. So what we have is this law that says you may use force, not deadly force, right? This is not a deadly force law. This is not a castle doctrine law. This is a law about force
And threatening deadly force.
and threatening deadly force
Yeah.
to defend your premises against trespassers. And by premises, we are making crystal clear here by just changing a couple words that we mean your real property, right? Or some structures on your property. And we've changed this as well.
Yeah, so we'll just read off what this change in definition will now read. For purposes of this section, premises means real property or any structure, movable or immovable, permanent or temporary, adapted for either human residence or lodging, whether occupied or not. And so, I mean, we'll put it up on screen, but you see they're striking a lot of ands and adding
Yes.
ors.
I actually don't think so. When you look at that first and to or, I don't think that changes the law at all. What I think that does is make it so your rogue prosecutors
Yeah.
can't go in and argue something stupid. I think the clear intent of the law is the same. To me, that's a step off prosecuting attorneys change. Personally.
Yeah, and when we look at reading the law kind of principles, we look at whether something is disjunctive or not, and the way that the and is currently written, I think it's already disjunctive.
I think so too.
But I think this makes it super crystal clear. So
Very clear.
we see what the law said currently. We see what this proposed change is. Is this a good model for other states? But before we talk about that, let's hear from our friends at American Hartford Gold.
As part of the firearms community, one lesson's clear. Relying on the government for protection, whether it's your life or your wealth, isn't smart. With soaring inflation, major economies abandoning the dollar, bank failures, and talks of government control through a digital dollar, the current state of affairs is uncertain.
Having a plan to safeguard your life savings from failing corporations and currency conflicts is crucial. That's where American Hartford Gold comes in, a precious metals dealer we trust.
They can guide you in diversifying your wealth portfolio with physical gold and silver. They offer incredible products, customer service, have a 5-star rating with thousands of reviews, and an A+ from the Better Business Bureau. On top of that, they support the channel and have an incredible offer to share with our community.
When you contact American Hartford Gold, tell them the armed attorney sent you, and they'll give you up to $5,000 of free silver on your first order. To learn more, text attorney to 65532 or call 866-856-2380 or check out the link in the description.
So let's talk about, is this a good change for other states? So, currently, let's just make it crystal clear. Currently, the law says it has to be real property, and it has to be, and I guess where the confusion is that it has to be human lodging.
Yes, so that's really, I mean, the only significant change here is the both to either, right? So it was your land, your real property, or it was a structure or improvement on said land that was adapted for human lodging, human residence and lodging. Whereas now it is human residence or lodging. So I mean, hypothetically now, your barn is included.
Yeah, your lean-to,
right?
Shade structures where animals sleep. I mean,
Yes.
we're talking about, now we're removing the word human from it and we're opening it up to potentially more structures.
Yes, which is so insignificant. And again, I mean, look, is it a good thing? Yes. Clarifying self-defense law, always a good thing. Is it oh my God, we're allowed to hunt human beings now that the Democrats in Arizona are making it out to be? Under no circumstances, because number one, that change is very small. The other very small change is only clarifying, it seems, and we are still living in the world. Think back to the very beginning of our discussion. We are still living in the world where this is not an authorization statute.
Right.
It's not
It's
a
a-
presumption.
Yeah, exactly right. It's a justification that would otherwise exclude criminal responsibility. So still get charged with a crime, but you can present evidence, some evidence to show that what you did was reasonable and immediately necessary.
Right. This is telling the jury they don't have to automatically find you guilty because you used force in your barn.
Yes.
They can say, oh, it was in the barn. Okay, move on. Now, did he do the right thing?
Yeah, I mean, I'm just thinking of ridiculous scenarios. You know, you go up to a group of people hanging out in your lean-to, give them all cigarettes and start going crazy on them. Guess what? You're going to go to prison for a murder forever.
Right. Yes. Fair.
So this is this isn't one of those scenarios.
Yes.
All right. I think the next kind of important question is this a good model for the rest of the states? There is one good thing about Arizona law that I wish more states would do, and they clarify that the threat of deadly force is justified. And I think that's a little unique, and I think this opens it up a little bit, and I kind of like that.
I love that. So here is a different example.
Yeah.
In the state of Texas, we say that, well, you know, you can only use deadly force when deadly force is necessary. And then you have this issue is pointing a gun, deadly force. And here we know that, I mean, that's the threat of deadly force, and that is justified here. The state of Texas goes a different way, says actually pointing a gun, which is, I guess, the threat of deadly force, is actually just a use of force. And that lives in a weird statute. And to quote Edwin Walker, when you explain that statute to a prosecutor, they look at you like a dog watching television.
Yeah, I've experienced that.
No one reads it. No one understands it. They choose to completely disregard it because it lives in a weird separate section that no one pays attention to except for people like us. And so, yes, this is a fantastic model. Every single one of every state statutes that authorizes a use of force should include the words or the threat of deadly force.
Yeah,
Every single one.
Yeah, this force is justified to stop trespassers. Producing a gun counts as force. You know, having those things separated from apart, very confusing, very difficult for police prosecutors to understand. So I think putting that front and center, and then this expansion to the structures, I think that kind of accomplishes the goal.
It accomplishes the goal. Now, it is not what either party claims it to be. I will, as hard as I am on Democrats all of the time, I will be moderately hard on the Arizona Republicans for this. It is not an expansion of the Castle Doctrine. It is not a huge expansion of anyone's rights.
It's also not Hunger Games.
It is also not Hunger Games, right? It is good law. It is good legislating. However, I think it is.
I think it's more even-keeled than either side wants to give it credit for.
Far more that is well put.
Yeah.
Far more even-keeled than either side will give it credit for.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, question and comment for us below. If you want a little bit of background as to why Arizona is proposing this law, check out these videos here on the current prosecution of an Arizona rancher. And until next time, we're the Armed Attorneys.